All right, so let's talk about the Supreme Court. Specifically, the Supreme Court has 9 members, 8 justices, and 1 Chief Justice. Our current Chief Justice is John Roberts. Note that the Supreme Court has an odd number so that they can have a majority when a decision is being made. So they're never going to have a split tie thing. Someone has to make sure that a decision is made. So the Supreme Court has the final say in matters about interpreting the Constitution, acts in Congress, and treaties the U.S. has made. So major decisions get made by the Supreme Court. The greatest power the Supreme Court has is the concept of judicial review, the ability to determine what is constitutional. So the ability to read the Constitution and look at a law or a case being brought to them and say, yes, that follows what was written in the Constitution, or no, that was not. So the concept of judicial review came about in the case of Marbury versus Madison. So in Marbury versus Madison, this was when there was a change in presidency. So the previous president, John Adams, was leaving office, and right as he was leaving, he appointed a bunch of what are called midnight judges, so people put in at the last minute to further his political agenda. So he appointed Marbury as a judge just as he was leaving. And when Jefferson came in and he did not agree with the same policies that Adams did, he told James Madison, who was helping him run things, said, "Do not let Marbury have the job. I do not want him or people like him in my courts because I don't agree with what they say." And so Marbury said, "That's not fair," and sued. And so the Supreme Court at this time did not have a lot of great power in deciding how things went, but the current Chief Justice came up with the idea of judicial review, where they were able to say, well, let's look at the Constitution and see what it says, and if it agrees with what the Constitution says, it's constitutional. But if what you did is something that the Constitution says is not okay, then it is not constitutional. And everyone was like, all right, that sounds fair. And so they decided that Marbury was in the right, that he shouldn't have not gotten a job. However, they also said, the Congress said that was not a decision that the Supreme Court should be making. It is not within their jurisdiction. So in the end, their decision was ignored, that Marbury was in the right. However, just because their decision wasn't followed does not mean that judicial review was not established at this point. So that's the biggest thing you should take away from Marbury versus Madison. So, jurisdiction of the Supreme Court. The Supreme Court can hear has appellate and original jurisdiction. That means they can hear appeals, and they can also have their own cases that start with them. So with original jurisdiction, the Supreme Court handles matters that involve 2 or more states. So California and Texas are disagreeing about something, so they handle that. Or cases brought against ambassadors or public ministers. Generally, most of what the Supreme Court hears, however, is appellate. So when appealing to the Supreme Court, it's important to note that the Supreme Court gets a bajillion cases every year. They get 10,000 cases at least every year, but they only let about a couple hundred actually get to the Supreme Court to handle, because there's just no way. That's why there's inferior courts in the first place. The inferior courts handle less. The other stuff, so the Supreme Court can handle the big deals. So there's 2 ways to make an appeal to the Supreme Court, so you can have an appellate case. There's the writ of certiorari, which is a lower court has to send up its record for the Supreme Court to review. So they send up what their decision was on a case, and the Supreme Court looks at it and goes, all right, we like what you said, or no, that doesn't seem right. And then there's the idea of certificate. So the lower court didn't make a final decision, or they made a decision that was unclear, and they asked the Supreme Court to make a final decision for them. So hearings in the Supreme Court go like this. The Supreme Court hears oral arguments for the case first, and then they accept briefs. So those are written statements on each party's legal stance in the case. So the defense writes something saying, this is what happened to me, I've been wronged, or whatever, and then the prosecution brings up what their statement is. So here's what we think happened, here's what we think happened. That's a brief. Justices confer to decide if they'll accept a case or not after that. So they look over the briefs after hearing the oral arguments, and they decide, okay, do you want to handle this? Do you think this is our job? And then the other justices go, yeah, I think it is, or they decide not to. So when they do decide whether or not they're going to hear a case, they're going to proceed with a case, they announce it, and then they announce who won the case. So they confer for a while, and they decide, who did the defense win, or did the prosecution win? So who wins and who loses is decided by majority opinion. Majority opinion is when the court details why it made the decisions it did. So see the bottom? Yes, no, yes, yes. 3 yeses to 1 no, that's majority. So, and with majority opinion, once they declare the court has decided that the defense wins, they say, all right, here's why we think the defense won. That's what majority opinion involves. And then there's 2 minor things attached to it called concurring opinion and dissenting opinion. With concurring opinion, another justice who agrees with the majority opinion from the Supreme Court says, yes, this is why this case won, but I'd like to make a point that there's an extra reason why they won. And here's what I have to say about it. Dissenting opinion is when the 1 no to the 3 yeses expresses why they think the majority opinion is wrong. They're allowed to say it, and they're allowed to articulate it for future people to read, but it's not going to change anything. They're not going to reverse what they decided already. And that is it for the Supreme Court. Okay.